All right. Thank you very much, Jackie. Yeah, here at the Seminole County Criminal Justice Center, they are still in that sidebar as we await the start of the Frye hearing. Let's bring in right now News 13 legal analyst Jaya Bilani, who is standing by right now. And so, Jaya, you know what? Judge Deborah Nelson has a tough decision to make here about whether or not to allow those 911 calls, expert analysis into court for those 6 jurors and 4 alternates to hear. What do you think she needs to hear, or what is going to be the deciding factor of whether or not that should be admitted into evidence or to testimony?
I think she's going to have to hear that the Frye test, whether it's accepted by the community and whether or not it's going to be not confusing to the jury. She's got a tough decision here, because if she denies it from coming in, she's facing an interlocutory appeal where it could hold up the beginning of the trial. If she allows it, then she's setting herself up potentially for an appeal after the trial if he's found convicted by the defense. So either way, it's a really tough call for her.
Yeah, so you've been listening to this testimony and these hearings on and on about whether or not to allow the 911 calls. From your opinion, what do you think? Do you think the defense or the prosecution has made their case about whether or not it should be admitted?
I think the defense had some great experts. I mean, the prosecution with the whole looping, and just from what the defense experts have been saying against the prosecution's expert, I think the defense has a great ground to not have him admitted. The defense experts explained the shortness of the tape. They explained everything very clearly. The problem is of course the interlocutory appeal, and if it is admitted, it's going to just be confusing for the jury, because you're going to have so many experts coming in on this one issue regarding the time frame and looping, and it's a definitely confusing issue. Anyone who's been watching will know that.
You know, as an attorney, I always wonder how much of a game changer is it for how you prepare for this case. Here we are, the trial and opening statements are going to be Monday at 9 o'clock in the morning. It's Thursday afternoon, and they are still arguing whether or not to allow that in trial. How much does that set you back as an attorney in preparing for Monday morning and for the duration of the trial?
It makes it very difficult, especially because you don't know. In your opening statement, usually you lay out everything that the jurors could potentially be hearing throughout the trial. Right now, they can't even prepare for the opening statements because they don't know what's coming in and what's not coming in regarding this 911 tape. They're also preparing so much just to get through this one hearing. They're not having time to prepare all their witnesses. Granted, it's been 16 months, but a lot's been going on with deposition, so it does set them back a little bit. I'm sure they've been working late nights, and it's going to be a rough weekend for both sides.
Yeah, I think I saw a little yawning from Donald West. Might be a little tired. It's been some long days inside this court. All right, Jaya, please stand by. We believe court is back in session. Let's listen in.